Hello and welcome to our webinar about Brexit and contracts. With the current situation with COVID-19, we're having to do this online, and Clark and I, who's presenting with me, are in different places in our own homes today, so forgive us if that causes any background noise. I'm David Lowe. I am one of the organisers of ThinkHouse, and I lead our commercial contracts team and our Brexit unit. And therefore I spend my time negotiating and drafting contracts and advising people on contracts they want to make.
And I'm Clark Sargent. I worked for a long time, a partner in our commercial litigation team. I'm still doing litigation work, but not as a partner now. And one of the things that I am doing is thinking about the firm's own Brexit planning and issues for clients arising from that.
And so today what we're going to try and do is to gather together the contract issues that come out of Brexit. What are the issues that I'm thinking about when I'm advising people on creating contracts, or indeed from Clark's point of view, what are the issues that come up when contracts start to fall apart? And so here on this slide, I've set out today's agenda of the key issues we're going to tackle. Obviously, the big issue is the border. That's the big thing that makes a massive difference on contracts, the hard border between the UK and the European Union. We're going to go through force majeure, because we get a lot of questions about is Brexit force majeure. And then we're going to talk about issues that are coming up like regulatory divergence, territory. Clark's going to talk about claims and litigation and privilege. And at the end, we'll wrap up with a brief action list. So as I said, the big issue in Brexit is the border. This is the key change that's going to happen when we exit the transitional period and properly leave the European Union. At the moment, the border between the UK and the rest of the EU is no different than crossing the English and Scottish border. You simply drive your truck onto the shuttle or onto a ferry, you travel over to France, and you carry on. There are no custom posts, there are no forms that need filling in. It's just a normal journey. Post-Brexit, that all changes. That border becomes a real and hard border. We don't know exactly where that's going to be, because that's the subject of negotiation. But certainly the indications from the UK government is the expectation that it'll be quite a hard border. Export declarations will need to be filled in. Import declarations will need to be filled in. Goods might be inspected. Certificates might need to be provided. Duties might need to be paid. It will feel like the border that we have between us and, say, the USA or Japan or South Africa. All of the formalities of crossing the border will apply. So what does that mean for us in our contracts? Well, the obvious first step is the risk of duty, tariffs, and similar measures like quotas. That brings a cost and a responsibility. And like any other cost or responsibility, you'd want your contract to be clear. Who is responsible for any export duties and tariffs? Who is responsible for the import duties and tariffs? Whose problem is it if they're not paid? Are all the kind of questions that you'd obviously want to anticipate and deal with in your contract. Then there's also time and delay. We're used at the moment that as long as the weather's good, the trucks can travel. And so we don't really concern ourselves very much about worrying about the risk of delay in between the UK and the EU border. But of course that will change. The border will become harder. Even in the long term, it will take more time to cross that border. And in the short term, there is a risk of at least congestion at the border while we adapt, if not total chaos, depending on the level of change required. And so there is going to be a significantly higher risk of delay at the border. And again, in our contracts, we'd want them to be clear about whose problem and cost that is. Costs of crossing the border are going to go up. Logistic carriers will charge more because they will have more to do and they will take more time, and therefore they'll need to pay their drivers more money, etc. So again, the carriage costs are going to become more significant. And then finally, the big question for everyone is just practically, how do you cross this border? How will you fill these forms in? You know, who's going to fill those export declarations, import declarations? Will customs brokers need to be appointed? Well, you don't really know whose job it is to put those arrangements in place if you haven't been clear about who takes responsibility for the duty, the tariffs, the time, delay, and costs. And so that's why delivery points really important. Here's a picture showing on the left-hand side the seller's premises, on the right-hand side the buyer's premises. Where the delivery point is along this line is going to make a huge difference. You are the seller and you deliver on the left-hand side, you've got less to do and you've got less responsibilities. But if you're the seller and you're delivering on the right-hand side into the buyer's premises, you've got a lot more to do and you're going to need to concentrate. Now, it's going to be really important in your contracts that you're making it clear where is the delivery point along this route. Currently, it's not uncommon for people to be very unclear in contracts between the UK and the rest of the EU because it doesn't really matter at the moment. Going forward, it will begin to matter. If your contract isn't clear where on this journey the parties' responsibilities hand over, then you're almost certainly going to have a dispute because it will be worth having an argument because there'll be money and time and cost and risk involved. So what that means is it's really important that you make the delivery point in your contracts clear. That's the beginning of this. Is it on the left-hand side, the right-hand side, or somewhere in the middle? It needs to be clear. And if you make it clear, then you're significantly reducing the risk of dispute. It'd be a good idea to consider using Incoterms. Incoterms are international trade terms published by the International Chamber of Commerce, which are designed to help with international deliveries. By using an Incoterm like free carrier, FCA, that means it's being very clear who is responsible for what. Under FCA, the seller is responsible for loading the goods onto the truck of the buyer, if it's at seller's premises, and is responsible for clearing export, and the buyer is responsible for everything else. So with those three letters, FCA, you suddenly add a lot of the magic that you need into your contract. Now, there's been a new edition of Incoterms that were published in January 2020. So now you've got two good reasons to review your contracts. One, to make sure the delivery point is clear for post-Brexit. Secondly, to consider using the new Incoterms. Now, some of the issues we're seeing already coming up on this whole point about delivery point is, of course, as we've got to every cliff edge for the last 2 years, people have started to worry about where the delivery point is and their responsibilities. And we've already seen plenty of questions from people where it's just not clear in the contract where the delivery point is, which is also going to be awkward in trying to work out who is that cost and risk of the border. We're also seeing people who are regretting the delivery points that are set out in their contract. So, for example, if a buyer is committed to deliver duty paid, that means they have all of the responsibility of the border, all the responsibility for the tariffs, and so forth. And those kind of buyers are now regretting those contracts because they're then worrying about the border. So if you're a seller and you've committed to sell, deliver duty paid, that means you've got to deliver the goods all the way on the right-hand side of this picture. That means you take the risk and responsibility of the border. And we're seeing people regretting that because they're now realizing that they've now got the risk and the cost of the duties, the tariffs and the borders, and they've been trying to get out of those contracts. They've tried to claim it's force majeure, and we'll come on to that shortly. There are difficult arguments to make succeed, and those contracts will become distressed because if the costs and the risks of delivery are significant enough, then the seller might simply refuse to deliver, regardless of what the contract says. So I mentioned force majeure and frustration. And Clark's going to lead us through whether Brexit is frustrating.
That is a good question to start with, actually. Is Brexit a frustrating event? And we probably find ourselves in a position where only a lawyer can answer that question. No, Brexit is not a frustrating thing. The issue, of course, is in contracts that have been around for a while. Brexit has brought issues into those contracts that might not have been foreseen and dealt with at the time, and therefore, can you now get out of contracts because of the new things that Brexit brings with it? And actually, the starting position is generally that is going to be very difficult because largely Brexit is about money, and frustration and force majeure do not help you when it's just about it's more expensive. Now, there has been a big case in relation to frustration and Brexit in 2019, and it's the Canary Wharf and European Medicines Agency case. That was a case about the head office of the EMA, which was in London. And that was under an agreement for lease that was signed in 2011, a lease that was entered into in 2014. And then, of course, 2 years later in 2016, the UK voted to leave the EU. And the EMA, an EU institution, took the view that it could not be based outside of the EU, which is fair enough. And it therefore tried to get out of its lease. It said it was unprecedented that it should be asked to stay in London as the head office of an EU institution, and when the UK was leaving, and it claimed that the lease had been frustrated. Now, the court said no, it wasn't frustrated. The court said yes, it was entirely unprecedented. It might even have been, to some extent, unforeseen that this was going to happen, but it was not a frustrating event. Now, the reasons for that, at a sort of technical level, was because the argument for frustration was that it was outside the powers of the EU to have a head office outside of the EU. The court said, look, that just isn't going to roll here, because the EU can own buildings outside the EU, and that's fine. There's no sort of impossibility in owning a building outside of the EU. What you want to do with it is a different matter, but you can own buildings outside the EU. In relation to an argument on common purpose, the court said, yes, we understand that it was the common purpose that this was going to be a head office, but it's also a common purpose that you are going to rent a building, and that you have managed to achieve. And it was not a common purpose that it would be the head office of the EMA forever and ever and ever. And the reasons for that is because this lease dealt with some of the issues about stopping the lease early. So there were rights to assign, there were rights to sublet. The EMA had itself, when it took the building, sought a break clause, which obviously meant that it had in mind that it wouldn't be the head office forever and ever. Court said, look, you foresaw that you might need to leave, and you have some contracting provisions in there. What you're really saying is that it's difficult to sublet this building right now, and you want to get out of it right now. Well, that wasn't the common purpose. There's a sort of underlying issue here that the EMA had obviously had the building purpose-built under the agreement for lease, so it was proving very hard to sublet because it had things like a United Nations-style forum on one of the floors, because of the nature of the business that the EMA does. So the court said, look, not frustrated. Now, and sort of stepping back and looking at it on a wider basis, there's a whole issue that if this case, this EU versus the UK style case wasn't good enough for frustration, then nothing is good enough for frustration arising from Brexit. It's sort of like, you won't get more Brexity than this, and this wasn't good enough. There's also quite an interesting dialogue in the case about for frustration you need two things. You need impossibility of performance, i.e. the thing has become a wholly materially different level of performance, which the EMA couldn't get over here. There's also the issue about foreseeability. Is the thing that has happened unforeseeable at the time of the contract, so that it is understandable that you didn't provide for it in your contract, and it's not just that you left the risk to fall wherever it falls. And the court looked at that here, and it did say that in 2011 it accepted that Brexit was not foreseeable, because that was just so far ago. But it would undoubtedly be the case that Brexit was foreseeable. Well, certainly when we got to 2016, because in June 2016 we had the vote, we knew we were leaving. And that means actually also 2015, when the Tory government got in on the back of a manifesto in which there was going to be this referendum. At that point, it's foreseeable that the UK could have been leaving. And indeed, even before that, in 2014, the Tory party was saying that this would be in its manifesto. So what you end up with is actually the idea, and there's no date formally set in the Canary Wharf case, but it is clear that once we get to sort of 2014, 2015, Brexit is a foreseeable event. And you are not going to be able to argue for frustration as a matter of common law relief for something that was foreseeable. And the court will say it was simply down to you that you didn't provide for this event in your contract. So frustration doesn't give you a get out of jail card. So the outcome of this case and general thinking is Brexit almost certainly will not get parties out of their contracts on the basis of frustration. Now, that doesn't necessarily deal with the issue if you've got a specific clause in the contract, and we'll go on and have a look at that in a minute. But for frustration, it's going to be it's very difficult.
And I think, Clark, you'd agree with me. I think part of the reason for the court's decision was to send a message to say they're not particularly open for policy reasons, effectively, to a wave of claims claiming that Brexit is frustrating their people's contracts, because here was a contract where it could not have been anticipated that Brexit was going to happen, where Brexit has had a big impact, undeniably, but the courts weren't willing to have that discussion at all. And I think that's a signal from the courts, isn't it?
Yeah, this is one of many cases over the last 5 years where claims for frustration and force majeure claims have largely always failed. The courts are very keen now to find and support contracts in accordance with the simple words and provisions used in the contract. So finding ways to get out of what the contract says you will do have over the last few years been difficult. So we've had that with contract interpretation and the pullback from the business common sense. I can read a contract to be business common sense and therefore allow myself to do something that it doesn't sort of say in the contract, because it would make sense that I could do it that way instead of the way it says in the contract. Those types of claims are failing. We're going back to a much more literal interpretation. We've seen that in previous ThinkHouse, where we talked about Arnold and Britain and Ward and Capita, those cases. And in accordance with that theme, a lot of cases that have claimed mistake, common mistake, rectification, frustration, force majeure have all been consistently failing. So this is in that stream, which is you look at the contract, you see what it says, and that's what you do.
So this is a good point for me to take on force majeure, because many contracts have a force majeure clause. And the reason many contracts have a force majeure clause is frustration has always been a very, very limited right. The occasions where frustration have been successful are sort of ancient cases to do with coronations being postponed and such like, and as Clark said, very rarely succeed. And therefore, many people in their contracts put a force majeure clause in, so a contractual, express contractual remedy in the contract where certain events happen. Now that is a contract right, and therefore it depends what the contract says. It's not you say the word force majeure, wave of magic wand, and a load of words are added into your contract automatically. Not at all. You only get it if you say it. And every force majeure clause is different in my experience. There always are slight differences. So But let's take a normal force majeure clause. Will usually start by asking whether there is an event beyond the reasonable control of the parties. And so many people go, well, Brexit is beyond the reasonable control of a company. It just got done to them. It's the government making a political decision that has had this consequence. That's an event beyond reasonable control, therefore it must be a force majeure. And that's correct. I don't think you could say Brexit is within control of many companies. However, it needs to then go on to prevent or hinder somebody, and in a way in which they couldn't reasonably anticipate. And this is where the courts are quite restrictive in their interpretations, as Clark's just said. Where there are few cases on force majeure, but where there are cases on force majeure, the courts tend to take a narrow interpretation. And so they might go, well, yes, Brexit has happened, but firstly, if it was a contract that had been entered into certainly after the referendum in 2016, then you could have reasonably anticipated it. So you entered into this contract knowing that one day there was going to be a hard Brexit. So don't come back and complain, there's now a hard Brexit. Should have thought about that in your contract, and we're going to assume that you did think about it, and we're not going to let you off for it. So that's one challenge. The other challenge is pointing to how Brexit actually makes performance impossible or very, very difficult to justify a force majeure as well. And simply because it's a bit harder across the border, or that it's a bit more expensive, just isn't enough. And therefore, we don't expect for many force majeure clauses that Brexit is going to be an event that will justify a force majeure clause, but it does depend on the wording of the clause. And I emphasise the wording because we are seeing occasionally people adding into force majeure clauses express reference to Brexit, and that might make a difference. Now, that takes us to Brexit clauses, really. There was a lot of discussion following the referendum about let's just add a Brexit clause to your contract, and then we've dealt with it. And then, of course, that makes sense because every previous significant change in our law, usually the response has been, let's add a clause. Modern slavery, GDPR, Contracts, Rights of Third Parties Act. I'm now showing my age because I remember when that came in. The response every time has been, let's add a clause. However, the challenge with Brexit clauses, and Clark and I have talked about this before at previous ThinkHouses, is firstly, what will be the trigger? Those Brexit clauses I've seen are often referred to the UK leaving the European Union. Well, that case, that's happened already. We left the European Union in January 2020. It's just that we're now in a transitional period, which feels much the same as being part of the EU. So if your clause said on leaving the EU then, well, you should have already been implementing that. So that's one of the problems about what is the right kind of trigger. But then the other problem is, well, what is the consequence? Nobody really quite knows what the impact is, so it's difficult to anticipate, and actually neither parties weren't going to want to give ground. So most of the clauses I've seen that specifically deal with Brexit usually refer to having a bit of a chat and having a discussion and coming to some kind of an agreement, which is an agreement to agree. Have you got any comment on those clauses, Clark?
Well, I agree with you. I don't think they take you anywhere because, by definition, if you're going to have a Brexit clause that is of any effect, it's really just a break clause, i.e., when Brexit happens, we can break, and one party is almost by definition not going to agree to that, which is why you just have a chat. And if you just have a chat, well, that's unenforceable. And actually, you don't need a clause to have a discussion. You can just pick up the phone and have a discussion and seek a variation. And if you can agree one, you can. And if you can't, you can't. So I've never been persuaded that they're going to be particularly useful to a party, really.
Yeah, and it's interesting is that I have occasionally seen Brexit clauses in contracts over the last couple of years, but it's really rare. Very occasionally see it added as a force majeure event, but really rare, pretty unusual, because I think most people have gone through the same thought process and concluded it added little value.
It's also worth bearing in mind, isn't it, that when we talk about force majeure and we talk about frustration, the courts are in a mindset of thinking about radically different or impossible now to perform. That's what they're looking at, and they have consistently been saying that it is more convoluted to perform is not impossible to perform, and that it's more expensive to perform is not really a concern of theirs. Expense goes to price, and price is an issue for the parties to have sorted out. So that doesn't go to radically different. You can always make a loss on a contract. It doesn't go to impossibility to perform, which is actually, and I know this would be a different podcast, which is why the coronavirus issues that we're seeing at the moment are different, because they are actually imposing an impossibility to get across a border or to get a workforce together to make a thing or whatever. But these are about price and convolutedness, which is why generally that they are struggling to make any impact.
And I think it's really interesting about the European Medicines Agency case is the emphasis the courts did about on the issue that a contract allocates risks between the parties, and we shouldn't disturb that. And with a lease, there has been an allocation of risk between the parties as to what happens if either tenant no longer need this building. And the court pointed out the European Medicine Agency had decided to take that risk by having a long-term lease, and as you said, Clark, by adding subletting and assignment clauses to it to allow that to happen. So therefore, the economic with the agency.
And as part of the negotiation, they had sought the break clause. They hadn't been able to get that, but they had their extensive rights to specify the fit out of the building, and they'd been able to negotiate the rent and stuff. They just hadn't got their break clause. They had taken different things. The court said instead of having the break clause, that was part of the allocation of the risk. You did also just very briefly mention the Crellin Henry case, which I do think actually, if you now brought Crellin Henry back, the coronation case, I want to rent a room looking over the Pall Mall, and you look at the way the common purpose, the common intended purpose of the lease is discussed in the Canary Wharf case, Mr. Henry would probably have won that case, and Mr. Krell will have been bound by his letting. He would have still had to take the letting. He could have still have taken the room. He would have had a lovely view of the Pall Mall, whatever was going up and down it, be it a king in a coronation carriage, or be it just ordinary pedestrians. The purpose was met, which is you've got the lovely view of the Pall Mall. So I think if we had that case 90 years on now, it would have been decided a different way. There we go.
Yeah. And a separate podcast or webinar coming your way on COVID and coronavirus, because of course force majeure and frustration is going to be huge in that.
I do think if you really want to challenge a contract, the way to do it is material adverse change clause is more likely to give you a remedy, and the other one is change in law. And we very rarely look at change in law, but change in law provisions might be the way to get some form of relief, because you frequently get an obligation to look at amendments if there is a change in the law, and Brexit is lots of changes in lots of laws.
Yeah, so if you have a long-term outsourcing agreement which has a change in law clause, and that's pretty normal, the way those clauses work is then work out who's going to bear the costs of that change of law. And of course, a judge is just going to read the clause and apply it to reallocate the costs accordingly in accordance with the contract. Doesn't have to worry about whether it's a force majeure or not. So I agree with you, Clark. We might see change of law clauses bubbling up as Brexit happens and imposes costs. Material adverse change clauses, I also agree, will be useful or will be effective. Having said that, you rarely see them in English law contracts. Usually it's a change of law clause as opposed to a more general material adverse change. You do see material adverse change more in other legal systems contracts, because they have that concept in their own contractual code. And that's probably a point worth emphasising, is what we've been talking about so far about frustration and force majeure is very much from an English law perspective. If your contract is subject to another law, then it might well be different, because other laws in other countries approach this subject differently. Now, we better move on. So our next area is regulatory divergence. You will have heard from Kieran and some of the other speakers in our Brexit ThinkHouse about what's going to happen on regulatory divergence. Are we going to chlorinate our chickens and the Europeans are not? And what does that mean? But what does that mean in a contract? Well, in many contracts, you have an obligation on the parties to comply and fulfill their obligations in accordance with all laws, which normally is not usually an issue. Usually that's fairly obvious. But think about how this might work if you've got a contract between a UK company and a German company, one subject to UK law, which has diverged, its regulations have diverged from the European Union, and the German company is subject to European regulations. And the contract says you must comply with all laws. Well, just what does that mean? Which laws? I mean, one of the things we've done with our precedents is we've gone through them and stripped out the references in compliance of laws clauses to European directives and regulations, because we don't want to accidentally find that we've committed a UK company to complying to a set of laws which no longer apply to it. But even if you've done that, you've just got that contract between an English company and a German company requirement to comply with all laws, you're going to risk a debate about which laws. And Clark, I don't know how you see that would turn out.
Worth saying, isn't it, that an English law contract looked at by an English court will normally apply English law. So we'll read that as English law. So generally, you might get away with it, but it is the issue that if you have somewhere referenced, EU directives or EU regulations, whatever it may be, or EU standards, the court will obviously enforce those, because that is the choice of the parties to specifically reference them. So that is quite a challenge. We've also got the issue about exactly how much EU standards, how many EU standards will come in through EU retained law, quite how that's going to work. We don't really understand that yet, and you've got to be thinking about that as well. So there is quite a bit in this, in looking both backwards at old contracts and worrying about what the standards are, and looking forwards on your new contracts. We have seen a dispute over sort of specifications and standards in the Eon and Hogarth case that we've referenced in the notes there, where the an obligation to supply goods to a satisfactory standard prevailed over everything, and that is going to remain good law. So you can specify compliance with regulations, compliance with standards, and if it is still subject to it will be subject to the overriding duty to supply something to satisfactory quality, unless you specifically say otherwise. What you need to be careful of course, is that what you end up building up in the contracts is a hurdle of standards that you have to hit, and that simply means that you will end up having to hit the highest one.
Yeah, so I think the Eon case is interesting, because that was where the front end had this general obligation to comply with satisfactory quality and other requirements, and then the back end had very detailed specification, which potentially conflicted. And the message from that case is the courts will try really hard to read the contract as an entirety. So we've discussed about how it's important to stop and think, when you say compliance with laws, which laws? Make that clear, and then you won't have an argument about it. But also look carefully at the specification. See if you've introduced compliance with another law by the back door. Look at the standards and specifications. Are those ones that actually you will be able to fulfill in the future if there is regulatory divergence? Should you be referring to an EU standard? Maybe you want to refer to a UK standard. And try to make the front and the back end consistent, so that you're not leading the court to have to weigh up how to read them in the round, whether it's everything or just one or the other. Now, so far we've been talking a lot really about goods and how do you get the goods across a border. And we've just been talking about specifications, very much with goods in mind. What about services? Obviously services are a bit easier, and that's you don't have to carry them across a border, but bear in mind local laws, regulatory divergence could have an impact on services. It might be that you need the services to be certified by a EU certifier. ask yourself whether, as a UK company, if that's what you are, whether you're actually going to be able to get that EU certificate. It might be that you have to use a professional whose qualification is accepted by the local country. Well, post-Brexit, a UK professional qualification may not be seen as equivalent in another country like Italy or France. So you may have problems there. You may have problems about moving people quickly across the border to provide service support because there may be visa restrictions and other controls. So Brexit isn't just about goods, it's also about the services that are provided. And therefore, you do need to think through what is the impact and how you can provide in a post-Brexit environment. And you see that particularly, obviously, in financial services, which is very heavily regulated. And that gives you an example of how services post-Brexit can be difficult. You know, can somebody in London provide financial services to somebody in Germany? And that is exactly the kind of debate that will be going on between the UK and the EU to agree that. And if they fail to agree, then it will become difficult to provide certain services.
Oh, we're going to have a look at territory, aren't we? This is if in an existing contract, probably now quite a historic contract, you simply have a definition of territory as the EU or members of the EU. What might that mean? Well, what it might mean is you jolly well wish that what you'd written was all members of the EU from time to time, because that will certainly see you through. But if you have not written that, and you simply have all members of the EU, well, do you mean all members of the EU when you wrote it, or all members of the EU now that you are having a dispute about it, or an issue upon it? And the answer there is, in that circumstances, it would almost certainly be all members of the EU then. Obviously, the court will look for the intent at the time of the contract, but it seems to us that it must mean all members of the EU then, because otherwise, for example, you could have a Croatian manufacturer with a distribution agreement into the EU, members of the EU, countries of the EU, from before Croatia was a member itself. It then joins. Does that mean that that manufacturer can no longer sell within its own country when it never expected that at the time that it made the distribution agreement with the EU distributor? So we think it would mean all members of the EU then at the point of the contract. Obviously, a wiser one to use is all members of the EU from time to time, because we do know that people can join and people can leave. We might have thought only people could join, but now we know that people can leave as well.
And certainly best practice has been, really since the referendum, is to be in a distribution agreement, for example, to be very clear whether the territory is meant to include the UK post-Brexit or exclude the UK. And actually, we're worrying about Brexit, but there is a risk that other countries, we've had the risk in the last 5 or so years about whether Greece was to leave, for example, or indeed new members were to join. So it is important, really, in drafting contracts to just think, how do you want it? Do you want it to flex, or do you want it to stick as is on the day you sign the contract, and make sure the contract deals with that?
Yeah, I mean, if you were the UK distributor for an American manufacturer within the EU, you certainly wouldn't want to. You wouldn't want to lose all that distribution territory because of our Brexit, would you? So very important to say exactly what you mean.
Yeah, and I think that's where we'll see disputes. UK-based distributors with EU distribution rights suddenly realising they've lost the most important part of their sales potentially. If the US manufacturer then wants to appoint a new distributor for the UK.
Yes, that would be funny, wouldn't it?
Yeah,
or not.
And that is where I predict the disputes will be over the next year or two in that area.
Yeah.
So now we've been talking really about contract drafting, contract terms, but what we also need to think about are claims. What happens if a dispute arises post-Brexit? So Clark.
Yeah, okay. So these are topics that have been with us since 2016. Issues of governing law, issues of jurisdiction, issues of service, issues of enforcement, actually, when we get on to the next slide. All of this at the moment has been dealt with in EU regulations. We have always hoped that they would be replicated in the final deal. Now that we are having a conversation about a harder Brexit, the reality is they might not be, and we won't carry on with the sort of close cooperation with European judiciaries on governing law, on jurisdiction, on these topics. None of that means that any of this stuff can't be done when we are in contract between a UK company and an EU company. It can all still be done. It will all still work. There will be a solution. It's just that it's all going to be a bit more clunky and a bit more time consuming and actually a bit more costly probably than it has been under what has become quite a slick set of EU regulations that facilitate all of these things. So governing law, still really important that we put them in governing law clauses into contracts. It is the case that most courts in Europe, in the UK, will still enforce contracts in the words that they use. So if you put the governing law will be French law, it will be French law. You should still expect that. It's just that it isn't quite as, you know, it's up for dispute, whereas under the EU regulations, it's not up for dispute. There we go. Jurisdiction, there is an issue here about having to think a bit more about whether you do want the courts of England and Wales, or whether you will want the jurisdiction of an EU court, because you are thinking about where the problems might arise, but particularly where the enforcement might need to take place. Jurisdiction clauses, exclusive jurisdiction clauses, will still be enforced by UK courts and EU courts under the Hague Convention that we have just signed up to, that the UK has just signed up to. But it's exclusive jurisdiction clauses. Non-exclusive jurisdiction clauses, there will be more room for fighting. That is simply a fact when we have these UK to EU contracts. Jurisdiction also raises the much more, or brings back into focus the issue of, do you want a court jurisdiction or do you want an arbitration jurisdiction? Which forum do you want to use for disputes? And there, that takes you straight into the question of enforcement, where one of the great advantages of arbitration is under the New York Convention, arbitration awards are generally enforceable in most places in the world without much issue. Courts in most countries will recognise arbitration awards and enforce them under the New York Convention. Under not having EU regulations, our UK court judgments will not be necessarily readily enforceable in European jurisdictions. It is going to be like enforcing judgments in the rest of the world. And that is much more difficult. So important to think at the contracting stage, do I want a court jurisdiction or do I want an arbitration jurisdiction? Also at the contracting stage, I've mentioned service. We don't think about service very much, but it is something that is facilitated again under EU regulations. We can pretty much issue a claim form anywhere in Europe, pop it in the post, it will be served. That is fine. Much more, costly, clunky. And under Hague Conventions, again, actually we're going to be going back to using a 1965 Hague Service Convention potentially, which means that service will be months or years, not weeks, essentially, going forward. So I do think that when you're at contract stage, very important to think about the parties being asked to appoint service agents in the relevant jurisdiction that you have selected for disputes. Enforcement, as I said.
If I could just ask a question then. So if we had a contract between a UK company and a French company, and it was subject to the exclusive jurisdiction of the English courts, if there was a dispute, first problem is serving the court papers on the French company if you haven't got something to do with process agents in your contract, you'll then this Hague Service Convention. Therefore, it might take a long time. Yeah, is that step one? Is that correct?
Yeah. You would end up having to check with a French lawyer how you would serve proceedings in France under local French law. It's just a bit more clunky than now, because it's almost like two separate stages rather than just one stage of relying on the EU regulation.
Okay, so it just becomes, it's not impossible, but it just becomes harder and more expensive.
Well, it just becomes a bit more timely, really. It's time. We're very used to, we issue a claim form, and anywhere in Europe now, we can be pretty confident that will be served within, 2, 3, 4 weeks. But now we might be thinking 2, 3, 4 months. And if you've got a claim and you want to get on with it, you don't want to issue a claim and then wait for 2 months, or 3 months or 4 months, where you're worrying about getting it properly served. You just want to get on with it. And it's just less. It's friction, isn't it? It's friction again. Friction at borders.
Okay. And then continue with my example, UK French exclusive jurisdiction. I go to court. I get judgment. I now need to enforce it. Let's say the French company hasn't got any assets in the UK. I need to go to France to enforce it. Under current rules, EU regulations, that's relatively straightforward in that you can take your English court judgment and enforce it in France. Reasonably easy. But in a new world, unless something is done, a treaty is done between the UK and EU, it becomes harder, is what I was hearing. Is that correct?
Yeah, well, it would be like taking a Russian judgment into France. It would be no different. It would be like taking an Iranian judgment into France. It would be, we are the rest of the world to Europe, just like all of those other countries. So you would be effectively applying to register it as a foreign judgment in France in a way that under EU regulations, that happens as almost as a simple, easy, smooth, fast, quick, cheap process. Now that's a bit more difficult and a bit more discretion and a bit more open to challenge, and in some territories that could end up being a bit more difficult, because you end up with these territorial issues that we just self-governance issues that we just don't have under Europe. We're one big happy family in Europe, and now we're not. We're outsiders.
Yeah,
bringing judgments in.
So therefore, if you're drafting a contract today before the end of 2020, you either do what you're currently doing and hope that the UK and EU do some kind of deal to make this easy and carry on, or you use a court judgment clause, and as you currently do, and be pessimistic and just cross your fingers and have to deal with the hassle of enforcement another time and wait, or you go for arbitration. Is that the choice?
Well, yeah, absolutely. I don't think this by any stretch means that arbitrations are always favourable to court proceedings, because arbitrations, have their own benefits and they have their own drawbacks, and you have to weigh them up. It's just that, in that seesaw balance of which ones do you pick, the problems with enforcement put a weight in favour of arbitration and against the courts. It's just slightly changed the balance on the seesaw.
Yeah.
So you just have to apply more thought to that. And remember, of course, we don't have any reciprocity with any of these European countries at the moment, because we don't need reciprocity for reciprocal enforcement of judgments with any of these European countries, because we were in the EU and it was all dealt with under the regulation. So when we come out, it's not like there's a load of other stuff to fall back on. And we are going back 50 years, and we'll be digging out, was France ever a signatory to this treaty, that treaty, blah blah blah. We'll be doing it very old-fashioned ways, the ways that we thought we had long left behind.
Yeah. So my experience at the moment is that when I'm talking to clients about contracts which might be straddling the UK-EU border, is that most people are loath to change from what they're currently doing. What they're currently doing is obviously courts, and that broadly works, and people are hesitating to change wholesale to arbitration. I am seeing people change to arbitration for a high value long-term contracts, because where they really want that confidence of a system that will be in place, whatever. I do wonder, though, that people's attitude to this might well change over the next 6 months, depending on how the negotiations go, as the risks dawn on people, and therefore we might see more arbitration clauses, I would forecast.
Absolutely. I mean, it is the case that, court fees are more expensive than they used to be, but it is still generally faster, quicker, cheaper to issue a court claim than to get an arbitration started. You can't argue about issuing a court claim in the way that you can argue about issuing an arbitration claim and having an arbitrator appointed. There is more delay and cost in the arbitration route. So on small claims, you might just say, I'll get the claim, I'll get the judgment, and then I'll worry about the enforcement. That might be perfectly sensible still to do. It's just that then enforcing it in Europe, just in Europe, will be a bit more difficult than it used to be, and you need to start weighing that in.
Right.
It's also the case, by the way, of course, that the more this becomes costly and the more business then feeds back to the government that this is a problem, the more you then might see the government going back and saying, actually, we really ought to be looking at doing, reciprocity agreements or equivalent agreements with the EU on these, governing law, jurisdiction, service, enforcement points to replicate what we used to have, because it makes common sense. That would help UK businesses. It would also help European businesses. European businesses who contract with UK companies have got exactly the same problems in reverse. They're going to be no more pleased about it than UK companies are. Perhaps that will build a political pressure and something will happen. It's just that we would have assumed that would happen very easily if we were doing a very soft and, adhering to equivalent regulations, etc. type of Brexit. If we're doing a harder one, it will just take more political push and will to get there.
Great. So, final topic, Clark, is the issue of privilege.
Oh yeah, no, I put this in just because a few years ago we had the Akzo Nobel decision that in Europe, when the EU Commission was bringing competition investigations, in-house lawyers in the UK, their documents were not privileged in that kind of EU competition inquiry, because the EU views the in-house lawyer and their issue of total independence from their employer in a stricter way than we do in the UK. In the UK, in-house lawyers always have privilege, just like external lawyers, and that is different in the EU and different across, by the way, all of the 27 other member states. They all have slightly different rules on how they look at in-house lawyers. We're coming out of the EU, so that Akzo Nobel decision is just going to go away, because we shouldn't have EU competition inquiries on us anymore, so long as you are not doing, business through European offices in the EU. So it's sort of bye-bye to Akzo Nobel. The issue that then makes you think is, of course, well, hang on, what about now when you are a multi-office international company and you have in-house lawyers, either in obviously in your German offices, but also including in your UK offices, now generating documents which will be used within the European-based businesses? And do we suddenly need to be worried that because of the harder border between us, the European countries will now be applying a lot less privilege to come and get in-house generated documents when we have companies that have offices in the EU and the UK? Now, I pose that more of a question because I'm thinking about that. Will that happen? How will that happen? And I never like to say we have to wait and see, but there is an element of we will have to wait and see how that works out. But I am conscious that that is an interesting issue that might arise, that we see a harder time for in-house lawyers always maintaining privilege on their documents that they would have been very confident about whilst the UK was within Europe and we were never challenged on this issue.
Right. So although superficially it looks like good news with through of Axo Nobel, so good news for in-house lawyers in the UK, no longer do you have to worry about not having privilege on documents. Actually, what you're saying is that could
well, in an EU competition inquiry, and now actually when you lose that, will it actually be, you might lose it wider. You might actually lose it wider once you get anything that has a European angle on it, because they will be looking at it just going, look, we owe the UK no favours. We owe them no favours. It's our rules. Yeah.
So it's I think it's definitely somewhere we need to see how it unrolls to see how it works in the real world, don't we?
Absolutely. It's just something I'm conscious of that in-house lawyers might need to think about a bit more, particularly UK in-house lawyers might need to be thinking about a bit more than before. And of course, with other cases that are going on privilege at the moment that we don't need to talk about, but all of which are going to require in-house lawyers to be thinking a bit harder about making sure they maintain privilege.
Yeah. So that brings the conclusion to this review of the contractual impacts of Brexit, which hopefully will help you weigh up its impact and what you need to focus on. Certainly immediately after the referendum, there was a sense of panic in the air. People desperately, can I have a Brexit clause? Oh my God, the world's going to end. Feeling to that. I guess even if that feeling is still around, COVID-19 is probably overtaken us and reminding us what a real panic can be like. But I would say that most people were starting to come to terms with Brexit in early January 2020 and starting to more calmly work through the issues, because as we've talked them through today, none of these issues come as huge surprises. All of them are issues that can be dealt with, anticipated and worked through, and we do have the time to be able to do that. Think before you drink, or tap before you contract. The suggestion of thinking ahead about what to do. So think ahead about the border. How are goods actually going to cross that border? What do your contracts actually say now? How should they be amended to make that delivery point clear? Regulatory divergence, that's going to be probably the big story for the next 5 years, I would say, on this, is are we going to diverge and what is the impact? And so I'd say this is going to rise as an issue. This isn't a day one issue, because on day one, there isn't going to be regulatory divergence broadly. So it's not going to be an issue on day one. But in 3 to 5 years, it probably will be an issue. And therefore, making sure your contracts manage that issue now will set you up well for the future, so you avoid a future panic. On claims, you've heard about how claims are just going to be harder, more complicated. So you should be thinking about that and anticipating that in your contracts, weighing up whether you, on balance, the seesaw that Clark talked about, whether on balance we should be moving towards arbitration. Consider whether you should be including process agents, something that we've got out of the habit of doing over the last 20 years because it's just become less important. Maybe we need to do that. And then be mindful then of, if you have got claims, thinking quite hard how you're going to approach them to find the least painful way through it, because it will be more painful whatever happens going forward. We hope this has been helpful to you, and we'd love your feedback to hear what are the contractual issues you're seeing. What would you like to hear more from us about? Clark and I really look forward to hearing from you. Thank you.